sorry? For first-degree murder.
In counts 1 and 2.
Counts 1 and 2. We will give it, obviously, for second-degree murder manslaughter. It's not necessary for count 1, but sometimes the state wants it, sometimes they don't. It doesn't do anything for the degree of crime.
Yes, sir. Judge, we do, and I think I put this on the record in other cases, simply because if there's no factual finding made by the jury and the appellate court for some reason, if there's a conviction for first-degree murder and they find there's insufficient evidence, but sufficient evidence of second-degree murder or manslaughter, we'd like to have that finding by the jury.
So you do want that?
Yes, sir.
All right. Now, look on page 3. I have 3 versions of manslaughter. I have manslaughter by intentional act, manslaughter by culpable negligence, and manslaughter with both. Which version would you all want? State or defense?
Judge, we would ask for the intentional act, voluntary manslaughter.
Just relax.
Yes, sir.
How about you guys? Yeah.
Judge, number one, we would concur on the issue on count of first-degree murder that you decided as to the interrogatory verdict with regard to firearms. With regard to the manslaughter instructions, we would request that all of the manslaughter instructions...
You want culpable negligence?
Yes, sir.
Given these facts, you want culpable negligence?
Sir?
Given these facts, you want culpable negligence?
I would like to have it.
Okay, I'll give the version that... there are 3 versions in there. I'll give the one that shows culpable negligence and intentional act. And we'll not give the other 2. And by the way, well, the use of a firearm is different from manslaughter. Okay, we'll get to the escape in just a moment. See if there's anything else at issue. All right, if you'll turn very quickly, please, to page 8. We're really and truly starting on page 7 with instructions 3.9 and 3.9c. I presume, defense, you want 3.9c eyewitness identification?
Yes, sir.
Yes, sir.
That's a standard instruction I'll give it.
Yes, sir.
Turning to page 8. This is kind of a new instruction that the Supreme Court has promulgated a lot of these matters. But on page 8, there's an instruction with, which I think is used to, when a witness, a jailhouse witness testifies, but it has to do with whether a witness is giving some promise. Question that the defense wanted.
Yes.
It's standard, I'll give it. Okay, then I'll either give defendant became a witness or not, depending on whether he testifies.
Yes, sir.
And if he doesn't testify, I'll give 3.9d, which is at the bottom of page 8. That takes us to page 9. Does either side feel we need 3.9e defendant statements? The only statement I think it's come into evidence is this jailhouse remark that was testified to. State, do you want it? It's usually given for witnesses who are questioned by the police if you gave some sort of statement.
I don't want it because there's no...
You do or do not?
I do not because there was no interrogation.
Do you need it, counsel?
We can have just a moment, Judge.
Sure.
Thank you.
By the way, none of this is final. We'll have a...
I understand, Your Honor.
Well, that's the only question. We're going to answer whatever statements refer you to national press. Well, this is normally used for law enforcement.
I don't think it applies in this case, but
That's our quandary, Your Honor.
That's probably wrong.
Yeah, I don't think it fits. Judge, at this time, we will not request that. Now, obviously, I'd like to reserve thinking about it further, but at this time, we're not.
at this time you say no?
Yes, sir. That's fine.
I agree with that. Okay. And that takes us to page, that's it.
So you all do not want 3.9e?
No.
Okay.
Okay, now the next question that comes, I think, which is a matter of some concern, is the indictment has 4 counts. Count 4 was felon in possession of a firearm. There's no doubt that would be severed.
Yes, sir.
It has been severed. I've been proceeding under all these months that I've had the case that this was a 2-count indictment. But as counsel, you all pointed out to me earlier today, there was a 3rd count of escape. It wasn't talked about in any way, shape, or form. So I've taken the liberty of including it as that's a standard instruction on page 6. And you want to be heard on that?
Yes, sir. I think we have to exclude it in light of the fact it's not pronounced to the jury. It was not addressed with them in any way beyond the inferential evidence. I think it would be a violation of due process to proceed. So I would ask that we sever it along with the possession of firearm count. I don't think it makes any substantive difference in this case, in any case, except perhaps as an aggravating factor.
Well, there's an aggravating factor that I'm sure the state's going to urge escape defense. But I guess for the purpose of this charge conference, you don't want the jury to be instructed and be able to come back with a verdict one way or the other on escape. Correct. Is that right?
Yes, sir.
Mr. Harvey?
Anybody disagree?
No. Judge, we ask that it be read to the jury. It's a count in the indictment. There's no reason for it to be severed. It doesn't violate in its nature like felon in possession with the due process rights of the defendant. The fact that it was inadvertently not read last week doesn't cause any issues. The jury has heard the evidence. They'll now be instructed on the law. You're going to give them this law. I don't see any prejudice to the defense or the state or to the integrity of this trial. So I would ask that the instructions be given.
Your Honor, I think there's tremendous substantive difference. There are basically three charges that the jury can consider if the state's request is honored, and they were not led to believe there were such charges. They will be confused by that. We believe they will be confused by the fact that that was not addressed in the opening statements. And certainly all of us addressed the 2 counts of first-degree murder. I think it would be a due process concern if it were to be included at this late date. Go ahead. Go ahead.
Yes, sir.
Your Honor, my concern with this, and I think I'm diverging totally from co-counsel at this point, but I'll state it anyway.
Please.
Okay?
You mean
It occurs to me that if we sever this, then the escape charge would have to be in turn severed from possession of firearms by convicted felon from the escape charge as well, which means we're now picking 3 juries and allowing 3 separate juries, 3 separate opportunities to convict Mr. Morris of something out of the same transaction.
Well, we all know the practicality of that ever happening, but that's besides the point. But I don't disagree with you that you couldn't try counts 3 and 4 together.
Correct.
Have to try count 3. All right. All right. So, well, let me just ask, I guess, Mr. Howman, had we discussed this? First of all, had count 3, the escape charge, been in the factual recitation that we gave, that we agreed to, that you guys proposed, and had it been brought up or told to the jury, the prospective panel of 150 folks, what would you have done differently? What questions would you have asked differently than you did in voir dire? You certainly wouldn't have had any. There would be no basis to discuss that during the penalty phase, because that.
Right.
And with respect to any discussion during the first phase voir dire, I think all the typical questions were asked for burden of proof, presumption of innocence, et cetera. I just wonder what you would have done differently or could have done differently.
As far as voir dire, Judge, I tend to agree with you. My concern has to do with the confusion that would ensue if we address them by reading the indictment. We addressed the issues of the indictment in the opening statements, and no one mentioned the escape charge, and then they see this all of a sudden in the instruction. I think that creates potential for confusion of the jury, which could be deleterious to a fair and impartial verdict.
For the purpose of what we're doing right here now, the defense does not want the jury instructed on count 3. The state does.
Yes, sir. Judge, I just want to put something on the record. The factual recitation given to the jury included the fact that the person who committed the murders fled from the scene after Officer Curtis attempted to place him under arrest. So that factual assertion was made clear to the jury in voir dire last week. Also, in opening statements, neither myself or counsel for the defense, I believe, mentioned what the charges were per count. We talked about the fact, I talked about the fact that the shooter shot the officers, fled from the scene. What his obvious motive was to escape. I used that term, and to flee. So that was, the jury was put on notice then of what was going on. But ultimately, the defendant was indicted in July of 2010 with all of these counts. Counsel has been aware of this since the very beginning. By not objecting to anything last week, they've waived any argument at this point not to present this charge to the jury, simply because we overted to tell them about this last week. Judge, I don't see how this would create any prejudice. The jury knows the factual allegations. The state made the allegations in the opening statement that we would prove the shooter, the defendant fled. And lastly, the defense from the very beginning in opening statements has been identification. So how is identification of the person at the scene affected by an escape charge? It doesn't affect their defense. Their defense is our defendant, our client wasn't there, period. So I don't think there's been any showing of prejudice by the defense or any lack of knowledge of what was going on last week.
Well, first of all, I don't think either party has waived anything. I mean, this is all subject to everybody having his or her opportunity to be heard. And I will note that, just in passing, that in the event of a conviction for first-degree murder, one of the proposed aggravators is to escape from custody, right?
Yes, sir.
And I wonder if Mr. Morris would be acquitted of count 3, if that would affect your right to proceed under that aggravator. But that's beside the point. In any event, I'll make a ruling. You gentlemen have copies of them, hard copies. Jeannie also emailed them to you. Please review them to be sure that they're correct. By the way, if I give escape, does it have a lesser? I don't think it does.
No, Your Honor.
I don't think it has a lesser. Anyway, if you want any special instructions, email them to Jeannie. Tomorrow, if all goes as I think the state will finish its case hopefully before noon.
Yes.
If that happens, I'll address with Mr. Morris his right to testify or not testify. And then we'll proceed with arguments. And if we get to that point, your time that you wanted to state?
An hour and a half, Judge.
Counsel?
An hour and a half, it's fine.
I'll make a ruling on that, too, and I'll let you all know.
Yes.
Judge, just for the court's information, we have rough drafts of some proposed jury instructions. We're getting folks in our Tampa office to help us put those in form as soon as we can.
Roughly, what do they address? Can you know?
I don't have a list in front of me. You have that, Karen?
Just what do they have to do with, I'll know.
Judge, with victim impact, with aggravators, what the jury was fine with, how to weigh.
You're talking about second phase stuff?
Yes.
Oh, yeah, we'll talk about that. We're not even there yet. I'm talking about with this first phase thing right now.
No.
In fact, I'll get you folks a proposed second phase draft, and that's why I asked you earlier, in the event we get there, what mitigators you think you want me to, some lawyers want me to list mitigators, A, B, C, D. Some don't. They want a general. Just however you want to do it, I'll do it. But I need to know what to insert in there. And I have a rough draft that I'll get to counsel sometime tomorrow.
Yes, Judge, I apologize. I heard we do not have guilt phase proposed instructions at this time. Something may come up.
I understand.
This time we do not.
So we'll do a final charge conference tomorrow, and I'll let everybody put everything on the record you want. Or anything else y'all want to discuss before we leave? Counsel, anything else you want to bring up? Okay, all right. Thank you all. We'll see you folks tomorrow. Be here at 8:15 if you would, please.